jury back in, I want to put on the record an issue that came up, it's a fairly significant issue. During the testimony of our last witness, Dr. Young, there were expert opinions offered about causation of certain injuries that had not been previously supplied to either, to the court's understanding, the state of Ohio or the defense. And obviously that becomes problematic, particularly with the defense being entitled to have notice of those types of medical issues and so forth. So before I issue my ruling and determination how we're going to deal with that, I'm going to give the parties an opportunity to address the issue on the record. I'll start with the state of Ohio. Ms. Hiley, if you'd like to go ahead.
Your Honor, my understanding is the objection is specifically to the doctor's testimony that the retinal hemorrhages that he saw are most consistent with the shaking mechanism. And the argument is that that was not provided by the state. I do want to note for the record that the state has always maintained that this is a diagnosis of abusive head trauma. This doctor had provided that this was consistent with abusive head trauma. That abusive head trauma in the medical world can be shaking and impact, or impact. It's not a distinct, but those are all possible mechanisms of that abusive head trauma. And I believe that that has been known to defense, as well as the state has provided a bill of particulars where shaking is one of the alleged ways in which this may have occurred. Ultimately, and I want to also note for the record that the state filed a memorandum contra defendant's motion to continue trial back on November 27th. And in that, the state cited State v. Rich, 12th District, Butler, numbers CA 2012-03044, the Ohio site being 2013 Ohio 857. In that case, there was an argument that prior to the state calling the witness, the state provided defense with a PowerPoint presentation which contained additional information not initially in the report. The 12th District Court of Appeals stated that Criminal Rule 16 contains the word or, not and thus the state is not required to provide a written report with a summary of the expert's testimony, a summary of the expert's finding, a summary of the expert's analysis, or a summary, I'm sorry, I'm reading the wrong part. So the trial court, in overruling the objection at that point, found that Criminal Rule 16 does not require a summary of the expert's witness testimony and not, or it does require a summary of the expert's testimony and not a word for word, exact word for word. However, although I think that the case law would support this coming in, I'm not agreeing that it doesn't. The state does recognize that that specific piece of information was not known to the state and known to the defense. So we are in agreement with the court excluding that. Thank you.
Thank you, Ms. Hiley, and I do understand and note your distinctions. Who would like to be heard on behalf of the defense?
Well, I just...
For the record,
yeah, I'll come up here so I know. And for the record, we were on notice about Dr. Young's abusive head injury diagnosis, but that the full and extent of that diagnosis is contained on Defense Exhibit B that I cross-examined the doctor on. I'm happy to provide it to the court so it could be a part of the appellate record, and it just says, I agree, yes. Whether that's a sufficient summary or not, I would dispute, but I would like the court to know that in the doctor's 15 pages of notes, which is State Exhibit 19 and Defense Exhibit B, the only mention of abusive head trauma is 3 words, I agree, yes, and there's no mention of shaking. In the doctor's notes, there's no mention of shaking. In the abbreviated email of 3 words, it came as a surprise to me, it came as a surprise to the state, and we'd asked that it be stricken with respect to the instruction that the court is prepared to put forward.
Mr. Fagan, just because this is one of those points I have to clarify for the record's sake, is the defense of the opinion that any willful acts or discovery violations have been committed by the state?
No, we don't take that position, and we take our colleagues in good faith. There's been
All right.
no documentation that I've seen that even hints at a Brady violation or a Rule 16 violation. And I understood the witness's testimony to be that he brought this up on his own and couldn't remember if he'd specifically said anything to the state or its agents. I see nothing to corroborate that it happened.
All right.
You know, our view on, whether or not this is material or not, but our view on 16K is that a report, to comply with it, has to have a summary of the expert's qualifications, a summary of the witness testimony, the findings, the analysis, conclusions, or opinion, and none of that would apply to shaking as a mechanism for any of these injuries. So.
All right, thank you. The court agrees with the state in recognizing that at least based on the evidence that the court has heard to this point, the terminology abusive head trauma is kind of a all-encompassing use of terminology that can cover certain actions, including but not limited to shaking. And that's where this issue becomes problematic. The court understands that all of the records, all of the reports that have been provided in relation to this particular witness have been consistent and stated abusive head trauma, which, as I've just stated, is a broader category. To my understanding and knowledge, neither party has come into this courtroom this morning understanding or expecting that Dr. Young was going to testify as to one of the specific mechanisms that's encompassed in that terminology. If I'm stating anything inaccurate, just somebody raise your hand and correct me, that's fine. That is my understanding of the situation. When the doctor goes from preparing reports and summaries and expert opinions and whatever that include this generalized category, and then for the first time narrows it down to one of a specified categories of behavior encompassed in that terminology, nobody has any notice of it. The court recognizes, the state probably even suffered some prejudice as well in terms of how they prepared their case and arguments, whatever. But certainly, the court understands the defense. If they had known that the ophthalmologist was going to come in and offer that specific opinion, they would have at least looked into the possibility of getting their own expert to refute that finding, and they have not had opportunity to do such. So what the court is inclined to do after considering the matter, after also finding, and I think that the defense is not alluding to any bad faith, I'm not finding any bad faith, I have to look for the least restrictive measure of correcting this situation. I am going to give a limiting instruction to the jury that they cannot consider the testimony of the doctor in regards to the shaking specific mechanism that was provided on the stand. And so the record is clear, and I'll allow both attorneys to hear both sides, but when I say both attorneys, I mean all attorneys, to hear this for potential input. My intention is to instruct the jury, quote, "Ladies and gentlemen, you have heard testimony from Dr. Young. You are to disregard any testimony from the witness that the causation of the retinal injuries was from a shaking mechanism and that the potential and any potential resulting brain injuries therefrom. This is due to testimony that was not presented to either the state or the defense prior to trial." So that is what the court intends on instructing the jury. And again, the case law is well established that the court has to presume the jury will follow that instruction. So either side wish to be heard on the proposed instruction.
Nothing on behalf of the state.
No, sir.
All right.
Go ahead.
No, if you have something to add, go ahead.
Well, I
was
just,
gonna
going
call
forward,
it.
I think you're going to instruct, and then I don't know who the next witness is. I just for scheduling, I'd like everybody to know that I understand there's two other doctors, Dr. Dean, and then who will be a substantial witness, and then a treating Children's Hospital doctor who's a fact witness, who I wouldn't have I wouldn't spend nearly as much time with. So, and it's almost new.
Well, for scheduling purposes, because we are in the redirect, and I don't know how much redirect recross is going to be, we'll permit that, obviously, with this particular witness, then my plan is to recess for lunch. I'm not going to jump into another witness
Your
before we
Honor,
get into lunch.
I would ask if we could, it is Dr. Chima, it will be very short, I think we can get him in and out in 20 minutes. I really do, because he's not on it, he's just a fact witness. I just hate to have him sitting out here for that long, especially if they're away from the hospital when they're here, and I just hate to do that, if we could.
So is this something that we can anticipate by 12:15 at the latest,
Yes.
approximately, we could be finished with?
I think so, but I didn't know what I was going to say to Dr. Young, you know what I mean? So here we are.
I do.
I remember that conversation. Yeah. All right, we will, then I'll anticipate on doing that. If for some reason it appears as though something's going sideways, we will deal with the scheduling. Again, I try to be very mindful of the jury's time. I don't want to keep them here until 1, 2 o'clock, not eating yet, but it sounds like we should be able to accommodate maybe that other witness. Okay? All right, Ms. Wilson, if you would, please bring the jury in first. I will give them the instruction, then we will bring the witness back in to finish the examination. Ladies and gentlemen, please be seated. Before we bring our witness back in, first of all, I want to ask you to make sure any issues that need to be brought to my attention about the admonitions. All right, very good. All right, second bit of business, I need you to listen carefully to what I am about to say. Ladies and gentlemen of the jury, you have heard testimony from Dr. Young. You are to disregard any testimony from the witness that the causation of the retinal injuries was from a shaking mechanism and any potential resulting brain injuries therefrom. This is due to testimony that was not presented to either the state or the defense prior to trial. With that, Ms. Wilson, if you would bring in Dr. Young, we will finish up examination. All right, Dr. Young, welcome back. Please remember you are still under oath.
Yes.
I believe when last we left, Mr. Pagan, you had concluded cross-exam.
Yes, sir.
Ms. Hiley, do you wish to redirect?
I do, thank you.
Doctor, in discussing with Mr. Pagan your diagnosis and how you came to that reasonable degree of scientific or medical certainty in this case, you talked about excluding other diagnoses. In this case, when you came to that decision, did you evaluate the possibility of other things having caused the hemorrhages other than abusive head trauma?
Yes, I did.
And were you able to exclude any other possible cause other than abusive head trauma?
Yes, I was.
Nothing further.
Mr. Pagan, any recross based on the limited redirect?
Very limited. I'm going to do it from here if it's okay.
It's fine.
Am I invading your personal space?
No.
Okay, all right. I gave you Defense Exhibit B before.
Yes.
Okay. That's the email correspondence between you and the state with respect to your opinion about abusive head trauma.
Yes.
It's 3 words.
Yes.
I agree, yes?
Yes.
All right. Certainly, if you considered and excluded other diagnoses, it's not reflected in that report, is it?
Correct.
And it's not reflected in your notes?
Correct.
Your notes being State's Exhibit 19?
Correct.
Thank you.
All right, Dr. Young, thank you very much. Is this witness potentially subject to recall?
No, thank you.
All right, Dr. Young, you are released from your subpoena, but please do not discuss your testimony with any other potential witnesses, okay?
Yes, thank you.
Thanks, sir. Ladies and gentlemen, I note that it's 11:30. I have been told, as we've been planning the scheduling of all this, we believe that the next witness can be accomplished probably no later than, say, 12:50 at the latest, so I'm going to push ahead. Since you guys have just come back from a break, you should be nice and refreshed. We will push ahead with the next witness, and then we will accommodate the lunch period, okay? Who's the State's next witness?
Dr. Ranjit Chima.
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 All right. Ms. Wilson?
While we're waiting for the witness, let me just, it might be helpful to move this along if I just say this here.
You all talk amongst yourselves since Ms. Wilson got there. Let me know, we do have media cameras here. Do you have any objection to potentially your facial image being projected on media?
It's okay.
Okay.
Your Honor, may I approach a witness? I believe there's a number of exhibits still sitting up here.
Absolutely, yes. You may proceed whenever you're ready.
Thank you. Doctor, would you state your name for the record, please?
Ranjit Chima.
And
And sir, let me just start by project your voice, make sure everybody can hear you, okay? Sorry. Go ahead.
would you spell your last name, please?
Spell
Spell it.
Chima.
You're a doctor?
Yes, I am.
How long have you been a doctor?
I've been a doctor for nearly 19 years.
And where do you work at this point in time?
I work at Cincinnati Children's Hospital.
How long have you worked there?
I have been on faculty at Cincinnati Children's Hospital since 2007, so that this is my 12th year now.
And what are your current duties there at Cincinnati Children's?
I am one of the physicians in the pediatric ICU, or the intensive care unit, and I take care of critically ill children.
All right. Thank you for doing that. In that capacity, were you working at Cincinnati Children's between March 8th, 2018 and March 18th, 2018?
Yes, I was.
Did you have occasion to come into contact with Hannah Weshy, date of birth 1/11/2015?
I did.
And as a part of your duties there, is it your job to review and understand the procedures that this child has undergone in your care?
Yes, so for all children who are admitted to the intensive care unit, I was the supervising doctor and was responsible for care of this child during the stay in the ICU.
And as part of your duties there, do you also prepare progress notes and documentation of your care of a child?
We do that daily, yes.
All right, if I may approach the witness with State's Exhibit 150.
You may.
Children's Hospital. Thank you. Give the other. Thank you.
You say 150?
State's Exhibit 150, it will need to be written in. Doctor, if you want to take a moment to go ahead and flip through those. Doctor, in flipping through that, are you able to recognize that documentation?
Yes, I am.
And are those your progress notes from the care of Hannah Weshy
Yes, I
that
am.
you would have recorded? That they are?
Yes.
All right. In coming into contact with Hannah, were you aware of any procedures that she had received, any procedures that she had undergone, I guess is probably the better way to say it, at Cincinnati Children's?
So prior to me taking over her care in the hospital, she had come to us from an outside hospital,
And I don't want to kind of get into what information you have, but just specific any procedures that occurred at Cincinnati Children's. So
From
any
the time-
surgical procedure that you're,
So from when I took over her care, all the surgical procedures had already been done.
all right.
So when I took care of her, at that point, the surgical procedures had been done, and from when I took care of her onwards, there were no new surgical procedures performed.
All right. And when did you take over care?
I took care of her on the 9th of March,
And did you,
2018.
2018, thank you.
Yes.
And how long did that care continue?
So it was for a week.
In your care, did Hannah ever regain consciousness?
No, she did not regain consciousness.
Did her condition change in your care?
Her neurologic condition continued to deteriorate under my care, and that was what changed
Okay.
predominantly.
Doctor, can you tell us whether or not there was ever a determination of brain death in this case?
There was a determination of brain death in this case, and that was what was performed ultimately that led to her death.
Do you recall on what day the condition progressed or changed significantly in your care?
I'd have to look at the records, but it was about 3 days into her being in the hospital, it became clear to us that we would not be able to reverse the processes or even temporize what was going on in her brain. And at that time, we started thinking about doing a formal assessment of her brain by doing what we call a brain death examination. And so it was about 2 or 3 days into her course at Children's Hospital that it became very clear that this may go down the path of brain death.
Now, did that brain death evaluation then occur 3 days into her care?
No, it could not occur 3 days into it because for us to do a brain death examination, the patient has to have no medications in their system that would actually blunt or sort of cloud the neurologic exam. And she had gotten a lot of medications to induce a coma to help her brain and the pressure in her brain. And the levels of one of those medications was too high, and that precluded us doing a brain death examination.
So when ultimately were you able to do the brain death examination?
So I don't remember the exact date, but it was done. I had finished my week and I had passed it on to my partner who had taken the case over, and we were just waiting for those levels of the drug to come down to a level where we would be able to do it. And that was done the day she was pronounced, the day it was done. And so when the level came down, we were able to do it.
During your care of Hannah Weshy, were you able to see visible external injuries on her?
So while in the intensive care unit, we children are kept pretty still, and what I was able to observe was some bruising that was notable on her upper chest. And I didn't really turn her much because we were in a medically induced coma and she was so fragile at that state. So we don't like to move patients a whole lot. And so didn't really look at her back a whole lot, but definitely in the front when I used to examine her every day, we didn't notice bruising.
Oh. And could any of the care that Hannah received within the ICU have caused external injury to her?
No.
And why not? How do you know that?
Because children who have had sustained very severe brain injury, we keep them very, very
Objection.
still.
It goes beyond observations and what I did and is now analysis or assessment. Exceeds a fact witness. That's appropriate.
An ICU regarding a patient with a brain injury. So if you could go ahead with that.
So for children who have severe brain injury like this patient had, we keep them very still, and they actually get medicine that actually prevents them from moving, and also medicine that keeps them relatively in a comatose state, which she was getting. And so they don't really move spontaneously around. We actually don't even try to move them at all for any procedures and all if we can avoid them, because the very act of movement may increase the pressure in their brain, which we don't want to happen.
Nothing further.
All right, thank you. Mr. Pagan, any cross?
Just a couple.
You proceed when you're ready.
Good morning, still.
Good morning.
My name is Chris Pagan. I'm a defense attorney. Thank you for being here. Just a couple of questions. Do you appreciate or understand that you've been presented by the state of Ohio as a fact witness?
Yes.
Okay. So you've described your observations of what you did? Yes?
Yes.
Okay. And you understand that you have not been qualified as an expert to supply opinion evidence to this jury?
Yes.
And nothing that you've said in your direct testimony is an opinion within a reasonable degree of medical certainty?
Yes.
Thank you.
All right, any redirect?
No.
Subject to recall?
No.
Dr. Shima, you are excused, you're discharged from your subpoena, which means we're not going to be bringing you back. Do however ask that you do not discuss your testimony with any other anticipated witnesses, okay?
Thank you.
All right, thank you, sir, and what's your step coming down?
Thank you.
Ladies and gentlemen of the jury, I'm not going to presume that we can catch lightning in a bottle twice in terms of the duration of the testimony. So at this time, I am going to go ahead. It is approximately 11:45. We'll discharge for lunch. Please keep your lanyards on and your notebooks and things in your chairs. Again, please remember your admonitions, not to discuss the case amongst yourselves or with anyone else, not to do any research, not peeking around on the internet, anything like that, especially in light of some of the things that have taken place in the last 20 minutes. I don't want anybody out there discussing any of that. You've got your admonitions. I'll ask you about them when you return, okay? So at this time, we'll let you break for lunch. We'll leave the record on in case there's anything else to address before we go off the record, and then we'll all break for lunch. Start reassembling up here, say about 20 till 1, and then Ms. Wilson will be looking for you, and hopefully we'll start about 10 till 1, somewhere there. Okay?
Oh, absolutely. I'll give it to you when you come back. Yeah, because then you'll be afraid that you already got one.
That's right, thank you.
Enjoy your lunch.
Based on what the resulting answer was, obviously not allowing someone to move and giving medication so they don't move and so forth, that type of testimony it just reiterates and reinforces what my ruling was, in my opinion. And clearly that's not something that necessarily an expert would be delving into that type of opinion testimony, so I just want to supplement that ruling based on what the answer was. Any other issues we need to address before we go off record?
Nothing on behalf of the state.
Defense?
No, sir.
All right. Ladies and gentlemen in the back, again, I thank you for your cooperation and indulgences in terms of the emotional aspects of this. Please continue that decorum, both inside and outside of the courtroom. Again, any disruptions that come to my attention, even outside of this room, outside of my presence, can result in consequences. So with that, we will break for lunch. We will start assembling, like I told them, about 20 till 1.